Saugata Roy.
I rise to speak on the enforcement of security interest and recovery of debt, laws and miscellaneous provision amendment bill 2016. It was introduced by the finance minister on 11th May 2016 and it was immediately referred to a select committee. The select committee has submitted its report in July 2016. Fortunately, the select committee had no dissent notes. So we can say that the select committee was unanimous in its recommendations and hence we should not, and since the select committee was an all-party committee, we should not oppose the bill too much. Having said that, let me point out to some other matters to the finance minister who must be a little tense, because tomorrow the GST bill is to be introduced in Rajya Sabha.
It has not been circulated yet.
It has not been, but it's told that it is. I am reading in the newspaper. But the finance minister must be tense because of that reason. He must have been holding last moment parleys. Our party has supported the GST bill from the beginning. Only I hope that in the last moment the small contradictions that are there will be ironed out. Now, before I speak on the bill, let me point out that we are talking about banks, and the regulator of the banks is the Reserve Bank of India. I must put on record that the controversy made by a BJP MP on the Reserve Bank governor was absolutely unwarranted. It has lowered our prestige in the international market and ultimately the RBI governor decided to leave. He will leave in September. It should not have happened. Also, I want to point out that day we were discussing prices. Now, Reserve Bank is caught in a peculiar situation. It cannot lower interest rates till food inflation comes down. And unless RBI lowers interest rate, there cannot be big investments coming. So, the problem of prices, which is linked to the finance ministry, is also related to problem of industrial development. This I want to bring to your notice, sir. Now, the finance minister, being a lawyer, believes in bringing laws. There is nothing wrong. The Lok Sabha is for passing laws. But as I will point out a little later, that merely passage of laws does not change the situation. Where administrative and management actions are called for, just by having a law does not help anybody. And he has already passed. Political will is necessary, as Mr. Premchandran is pointing out from the back. Political will is necessary and that seems to be missing. Why? I'll tell you. He has already passed in this session the Bankruptcy and Insolvency Code, which takes care of insolvency problem. He has two targets. One is the target black money with laws. Number two, target the NPAs of banks through laws. But so far, we have not seen, in spite of passage of laws, much progress on these two fronts. Sir, before coming to the bill, let me paint a picture of the banking industry. The banking industry is at the worst situation that you can consider. Total, the stressed assets amount to rupees 8 lakh crores, that is 5.6% of the GDP. 8 lakh crores. The Reserve Bank governor in a meeting in February advised deep surgery. Since then, PSU banks have started making hefty write-off of stressed assets. What this is leading to? By December 2015, value of stressed assets was 7.4 lakh crores, which has now gone up to 8 lakh crores. RBI RBI has said that 10.9%, one-tenth of all loans are stressed. In the quarter ended December 31, 2015, the State Bank of India, the biggest bank for the smallest man, has posted 67% decline in consolidated profit to rupees 1259 crores for the third quarter due to higher provisioning for bad loans. The total provisioning for NPAs jumped to rupees 7,644 crores. That you are keeping separately. Similarly, other smaller banks have bled even more. Banks are in a bad shape and are in dire need for capital infusion from the government. Banks say that RBI ordered an asset quality review. That's why we have been forced to increase the provisions for stressed assets. But this is not enough, sir. You'd be surprised to know that depositors' money is with the bank. The public sector banks have written off rupees 1.14 lakh crores of bad loans during 2012 to 15. That will never be recovered. That is the condition of the banks. Now, can this be made up by laws alone, is my question. In 2014-15, the State Bank of India wrote off 21,313 crores. The Punjab National Bank wrote off rupees 6,587 crores. All is not right in the state of Denmark. Things are very, very wrong with the banks. I hope the government realizes that. Sir, now we can come to the laws that are there for recovering the bad debts. Recovery of debts due to Banks and Financial Institution Act 1993, through this DRTs or debt recovery tribunals were set up for loans. But you must be knowing, sir, that 70,000 cases are pending in DRTs. And though the law originally stipulated that all DRT applications should be disposed of in 6 months, for years together, due to adjournments and other reasons, cases are pending in the DRT. DRTs are not functioning rightly. So the other law that was enacted was called Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Now this gave rise to a new type of company called the Asset Reconstruction Companies. And this law is known as SARFAESI Act. Now, the recovery of debts, that is DRT, is available to both secured and unsecured creditors. But they must be banks or notified financial institutions. Cases over rupees 10 lakhs would be automatically transferred to the debt recovery tribunals. Now, what changes have been brought about? In this whole act, there are 2 parts, actually 4 parts. The SARFAESI Act is to be amended, the Act on DRT is to be amended, the Indian Stamp Act has to be amended, and the Depository Act has to be amended. Now, what are the new changes, amendments that have been brought? One is expeditious disposal of all applications. Second, it's an important change, is that there can be electronic filing of applications. 3, the priority of secured creditors is enforced through this DRT amendment. 4, debenture trustees will be treated as financial institution. And 5, empowering central government to provide for uniform rules for conduct of proceedings of DRTs. So these were the 5 changes made in the DRT Act. Now in SARFAESI, the section 13 went for serious change. First, to enforce security interests for NPAs without intervention of tribunals. If an asset was declared as a non-performing asset, you could directly go for SARFAESI to the asset reconstruction company. Number 2, any appeal against, in the new amendment, any appeal against action taken under SARFAESI will lie with the debt recovery tribunal. Now what will these asset reconstruction companies do? Asset reconstruction companies take over non-performing assets of banks at discounted rates and manage and dispose of such assets. This is a funny thing. If there is a 1,000 crore loan from a company to a bank, then the asset ARC will purchase that loan for 600 crores. Then it will take over the properties of the company, then it will sell them off and try to recover these 600 crores and make a profit in this matter. So this is the way we have thought of. Sir, I'll wind up. I'll not be very long. Am I speaking out of the point, sir? Or I am speaking in point?
Not out of the point, but you are going beyond the time.
Sir, then the RBI is the regulator according to the amendment. Next, to prevent what happened earlier is that a lender used to take loans from different banks showing the same property. That's why a central registry has been created. And now, to prevent multiple loaning from different banks on the same immovable property, Central Electronic Registry has been set up. It is operational till 2011. Now in the new amendment, there will be registration of creation, modification and satisfaction of Security Act by all secured creditors and provision of integration of the security system. That is, if a person had cars under the Motor Vehicles Act, if a person had immovable property, everything will be registered together in one registry so that bank at the push of a button will know that what are the properties and which have been given to the bank as a security. Right, like Aadhaar, yes. The idea is to create a central database of security interest in property rights. Secondly, it gives the Reserve Bank of India, which has been a little disempowered due to controversy over Raghuram Rajan, it empowers in the amendment, it empowers the RBI to regulate ARCs, to carry out audit and inspection of the ARCs, and 3, to impose penalty on the ARCs. 3 is a big change. There will be exemption of from stamp duty on loans assigned by banks and financial institutions to asset reconstruction companies. 4, the amendment will enable non-institutional investors to invest in security receipts by the asset reconstruction companies. 5, those who are issue debenture, even the government issues debentures, the debenture trustees will have same rights as secured creditors. 6, there would be specific timelines for taking possession of secured assets. 7, the priority will be given to secured creditors in the repayment of debts. 8, amendment of the Indian Stamp Act, amendment of the Depositories Act 1996, which will help banks and financial institutions to recover bank loans faster. Now, sir, lastly I'll say that we are members of the Finance Standing Committee, and the committee went deep into the problem of non-performing assets. We made certain recommendations. It was all-party committee. some of which has been implemented or followed by the government, some have not been. For instance, our committee pointed out that total credit takeoff in December 2014 was rupees 60.60 lakh crores. Total credit given by all the banks. Now, gross NPAs will touch 4 lakhs in 15-16. Our committee was not happy with the management of the problem both by Reserve Bank and banks. Banks have failed to notice early signs of stress on loans disbursed by them. Our committee has suggested that they should have intervened at the right time. Early and timely measures are necessary. 2, the important recommendation, forensic audit should be made compulsory for specific class of borrowers so that diversion of funds by promoters to unrelated businesses do not take place. 3, developing a vibrant bond market is necessary because most of these big defaulters are actually infrastructure companies. And for that, it's necessary to develop a vibrant bond market to finance infrastructure projects. It is our suggestion. That has not been done by the government. The biggest loans are all in infrastructure sector. Sir, you'd be surprised that the willful defaulters like Vijay Mallya owe the banks, PSU banks, a total of 64,335 crores, which is 21% of total NPAs.
Okay.
So each act must focus. So the suggestion was that every bank must focus on 30 stressed accounts so that Vijay Mallya incidents do not take place anymore. Sir, our committee also suggested that the RBI has not succeeded as a regulator in implementation and enforcement of its own guidelines. RBI must monitor and follow it up with banks. Lastly, we said corporate debt restructuring, CDR, has failed as a method to achieve desired objectives. Steps should be taken to take charge of failed CDR companies. Sir, the committee also recommended more DRTs to be taken up. Sir, lastly, I want to say that the recovery of NPAs through DRTs and SARFAESI Act have shown a decline from 2010-11 to 2013-14. So just because you have an act, it doesn't mean that NPA will go down. Lastly, in the committee, the select committee, many members suggested that agricultural loans, if they are taken as collateral, should be omitted from the scope of recovery.
Right.
That was not listened to.
Okay.
So lastly, I say we have supported the law. But the banking system is in its worst crisis. If one bank fails, there will be cascading effect. And what the finance minister should be concerned more than GST is the state of the banking system unless we do something. And sir, lastly I want to mention that the Reserve Bank Governor came to our Finance Standing Committee. He showed us a graph showing that the credit from public sector banks is less than the credit from private sector banks. Right. So actually credit is not flowing into the market. Industrial development and recovery are in a stagnant process. So with that I say, let the minister have all the act and the powers, but just as Benami Transactions Act should not lead to tax terrorism, similarly the SARFAESI Act should not relate to bank official terrorism, where they'll even drag the small lender to the court. Thank you very much, sir.